The law of contract, discharge of contract. A contract once formed imposes duties and obligations on the promisor and the promisee, which must be carried in fulfillment of their respective promises. The parties can only be freed from their mutual obligations under the discharge of contract. At the end of the video, learners should be able to achieve the following learning outcomes. What is discharge of contract? Discharge of a contract occurs when parties discharge or perform their duties or obligations as required by the contract. Performance thus signifies the end of the contract. Non-performance of the required duties and obligations by either or both parties will lead to the termination of the contract. In general, there are 4 ways parties can be discharged from a contract: by performance, by breach, by impossibility of performance or frustration, and by agreement. Discharge by means of performance. We will begin with discussing discharge through performance. The general rule is that performance must be exact and precise and should follow what has been agreed upon. A contract becomes discharged through performance where both parties have fully performed their contractual obligations. Section 38, subsection 1 of the Contract Act provides 2 elements. 1. Parties must perform or offer to perform their respective promises. In a simple term, when one performs his or her contractual obligations, he or she is discharged from the contract. For example, a contractor enters a renovation job for 20,000 ringgit. When the contractor completes his job according to the contract, he will be discharged. The client will be discharged when she pays 20,000 ringgit to the contractor. It is essential to take note that performance can only be pardoned if it is dispensed with or executed under law. If the performance is dispensed by law, the promisor did not perform his or her promise. According to Section 38, subsection 2 of the Contract Act, provides in the case of the death of the promisor before performance, if there is no intention to the promise, must be executed by the promisor. Therefore, the promise binds the representative of the promisor. But if the contract involves special personal qualification or skills of the promisor, the promise did not bind the representative of the promisor. In Carter v. Powell, the claimant, in this case the wife, cannot claim on quantum merit as her late husband did not fulfill the condition of the contract. You may also refer to the case Sumter v. Edge. Who should perform the contract? According to Section 41 of the Contract Act, provides a promise to be performed by the promisor or by the representative. The promisor himself should perform if the contract which is intended to be performed personally by the promisor. It is personal consideration are the foundation of the contract. The contract really and substantially has relation to the personal conduct of the contracting parties. For example, contract to paint a picture, contract to marry, or contract to sing. This requires specific person to perform the obligations. Therefore, it cannot be transferred to the representative. A contract can be performed by representative, which involves ordinary contracts, a contract without personal elements in the contract, for example, contract to deliver goods or contracts to pay. In the event of death of promissor, where the contract is for personal consideration, the death will put an end to the contract. Discharge by means of breach. A breach of contract is a violation of any agreed upon terms and conditions of a binding contract. The breach could be anything from late payment to a more severe violation, such as the failure to deliver a promised assets. A contract is binding and will hold weight if taken to court. For a successful claim of a breach of contract, it is imperative to prove that the breach has occurred. According to Section 40 of the Contract Act, it deals with the effect of refusal to perform wholly. If a party has refused to perform the promise, the innocent party may put an end to the contract. Every breach of contract discharges the other party from his obligations and confer a right upon him to sue for the breach. There are four types of breach: actual, anticipatory, material, and minor. Actual breach of contract is when one party delivers on their side of the contract, either improperly or incompletely performs their duties. For example, a vendor is paid for a shipment of stock and they either don't deliver them or deliver the wrong stock. That is considered as an actual breach. Anticipatory breach. In the case of anticipatory breach, an actual breach has not yet occurred. However, one of the parties has indicated that they will not fulfill their obligations under the contract. Therefore, anticipatory breach is basically the premature destruction of the contract. It may occur in two ways, where a party refuses to perform his promise in its entirety, or when a party does some act which disables him from performing his obligations. Material breach. A material breach of contract is considered the most severe type of breach. Typically, this type of breach involves a critical element of contract not being undertaken or provided as agreed. For example, when someone is purchasing a house, if the buyer completes all of the necessary paperwork, pays the seller at the closing, however, the seller suddenly decides not to sell or refuses to give up the deed and the key to the house, this will be considered as a material breach of contract. Another example, if you were to buy a computer online, but you only received the monitor, that would be a material breach of contract, and you would be entitled to take legal actions. Minor breach, also sometimes called a partial breach of contract or an immaterial breach of contract. A minor breach means that one party failed to perform some part of the contract, even though the specified item or service was ultimately delivered. For example, buying a computer online. If the computer was delivered, but the user manual was either missing or incomplete, if the seller sends a new complete manual, then there's no harm done. However, that action is considered as a minor breach. The case Hoxter versus De La Tour give an excellent example of an anticipatory breach. Discharge by means of frustration. Have you experienced frustration? Frustration originates from feelings of uncertainty and insecurity, which stems from a sense of inability to fulfill needs. If the needs of an individual are blocked, uneasiness and frustration are more likely to occur. Similarly, discharge by frustration is when a change in the circumstances which renders a contract legally or physically impossible to perform. Section 57 of the Contract Act lays down contracts becomes impossible to perform at the time it is made. It is considered as void ab initio, meaning that void at the initial stage. A contract that becomes impossible or unlawful after it was made, it becomes void. Section 57, subsection 1 of the Contract Act stated, agreement to do impossible act in itself is void. Impossible, here referring to impossible in the nature of things. For example, A agrees with B to discover treasure by magic. Now, this agreement is void as magic is considered as an impossible act. Section 57, subsection 2 of the Contract Act provides a contract to do any act which afterwards becomes impossible. It becomes void because of the impossibility or unlawfulness. For example, A and B contract to marry each other. However, before the time fixed for the marriage, A goes mad. The contract will become void. Frustration brings a contract to an end immediately and automatically. However, a contract will only be frustrated when the performance of the contract becomes impossible in a radically different way from what both parties intended. Accordingly, frustration will only apply to a limited range of circumstances. Listed are the elements that needs to present for a contract to be frustrated. 1. There must be a supervening event. 2. The supervening event must be unforeseen and outside the control of the contracting parties. 3. Neither party caused the supervening event. 4. Neither contemplate the supervening event. And 5. It must be unjust to hold the parties to the contract as agreed upon. Listed are instances of impossibility or frustration. Let us dissect the case Taylor versus Cardwell. Taylor rented a hall from Cardwell to hold a concert. However, before the day of the concert, the hall burned down. In this case, the supervening event is the fire. The fire was unforeseen. Neither Taylor nor Cardwell caused the fire and hoping that the fire took place. Therefore, the contract between them is frustrated, as the fire changes the circumstances of the contract, making it impossible to perform. Listed are other cases you can refer to. Discharge through agreement. If a contract is formed following an agreement, it is almost pure logic to suggest that the contract can also be ended by agreement without necessarily having performed. But what is required is mutuality. Idem modo cooritur, odor modo dissolvitur. What has been created by agreement may be extinguished by agreement. Section 63 of the Contract Act provides if the parties agree to substitute a new contract for it, therefore the original contract need not be performed. In a simple term, a new agreement between parties will abolish the old agreement. There are three main types of discharge by agreement. Novation, which is substituting an existing contract with a replacement contract where the contracting parties reaches a consensus. 2. Rescission. Rescission is an equitable remedy that allows a contracting party to cancel the contract. Parties may rescind if they are victims of a vitiating practice such as misrepresentation, mistake, duress, or undue influence. And 3. Variation. A variation is an agreement supported by consideration to alter some terms of the contract. Please refer to the following case on discharge by agreement.